In this episode, we will be discussing California residential lease renewal laws. The California Civil Code, Chapter 2, Section 1945 and 1945.5 addresses what happens after a term of tenancy expires and how the law governs lease agreements that are written to auto-renew. Accepting rent after expiration. If a tenant of real property remains in possession thereof after the expiration of the tenancy, and the landlord accepts rent from him or her, the parties are presumed to have renewed the tenancy on the same terms and for the same time, not exceeding 1 month when the rent is payable monthly, nor in any case beyond 1 year. Auto renewal provisions. Notwithstanding any other provision of law, any term of a lease which provides for the automatic renewal or extension of the lease for all or part of its full term, if the tenant remains in possession after the expiration, or fails to give notice of his or her intent not to renew or extend before the expiration, shall be voidable by the party who did not prepare the lease, unless such renewal or extension provision appears in at least 8-point boldface type if the contract is printed, in the body of the lease agreement, and a recital of the fact that such provision is contained in the body of the agreement appears in at least 8-point boldface type immediately prior to the place where the tenant executes the agreement. It is important to note any waiver of the provisions of this section is void as against public policy. So if the auto renewal provision is voided, the previous subsection, accepting rent after expiration, applies. For additional laws and articles, visit AmericanLandlord.com.